The Imperial Tobacco case in the Inner House is in tab 5 of the first volume of Authorities, and Lord Reid's speech is at page EF 588. That's the part where he starts to deal with section 29 of the Scotland Act. Lord Reid begins by referring to Lord Walker at paragraph 119, and thereafter at paragraph 120 explains that the relevant rules are contained in a number of provisions in the Scotland Act and makes specific reference to section 29. And he says it's necessary at this point to consider section 29(2)(b) and 3. As I have explained, section 29(2) states that a provision is outside the competence of the Scottish Parliament if it relates to reserved matters. And he quotes again from Martin against Most at paragraph 49. Thereafter, Lord Reid says, I respectfully agree. In ordinary English, relates to does not mean the same as affects, and although it is a wide expression, it cannot be intended to give such wide construction as to invalidate all legislation affecting matters listed in Schedule 5, however slight, indirect or remote the effect may be. The practical considerations which led to that conclusion in the case law relating to Canada, Australia and Northern Ireland are equally cogent in the context of the Scotland Act. At paragraph 121, he went on to say deciding whether legislation relates to a reserved matter involves two stages. First, determining the meaning of the words defining the reserved matter, and secondly, determining whether the legislation relates to that matter. At the first stage, it is to be noted that the Scotland Act doesn't adopt a double enumeration model, but defines the Scottish Parliament's powers by implication, as what remains once reserved matters have been excluded. It follows that, unlike the position in Canada, the interpretation of the reserved matters should not reflect any assumption as to the extent of matters which are not reserved.
This is all, I mean, I remember this coming back to this is quite an early case, and it's against the background of arguments where people were trying to rely on authorities and approaches adopted in other jurisdictions,
that's right.
Such as Canada and Australia and indeed Ireland. And I think we were trying to explain how the position under the Scotland Act differed from those under other schemes.
Yes, so that's certainly what my Lord is dealing with there at 121, but I think it is important to look to what he said immediately before that, which is that in ordinary English, relates to doesn't mean the same as affects, and although it's wide, it can't be intended to give a wide construction as to invalidate all legislation affecting matters listed in Schedule 5. And the words my Lord used are however slight, indirect or remote the effect may be. And certainly the issue about how you deal with the Scottish legislation against the background of the position in Canada and Australia was relevant. But what my Lord went on to say in paragraph 123 was this, that Schedule 5 listed matters, not purposes. Since the question whether a provision relates to a reserved matter is to be determined, read short by reference to its purpose, it appears that the purpose of a provision is to be treated as a pointer to the matter to which it relates. Once the purpose of the provision has been identified, therefore the remaining question is whether the matter to which it points is within the scope of the reserved matters listed in Schedule 5. That question may be straightforward, or it may be more complex depending on the circumstances. At 125, my Lord then went on to say, as Lord Roger observed in Martin against Most, the purpose of a provision will often be clear from its context in the Act in question. The Court can also consider extrinsic material which is relevant to ascertaining the purposes which the provision enacted to achieve. as Lord Hope indicated at paragraph 25, the Court is also expressly required to have regard to the effect of the provision. But what I think is important is when we go over to paragraph 133, we see how my Lord brings all of that together. If I take my Lord to that, in the context of the Imperial Tobacco case that dealt with the display of tobacco products and the effort made by the legislature to reduce the attractiveness of these to children, at 133 my Lord said this: I've set out the terms of Section 1. It begins by prohibiting the display of tobacco products in places where such products are sold, subject to a discretion conferred on the Scottish ministers by subsection 4, to provide that no offence is committed by display which complies with prescribed requirements. It then provides a limited exception in respect of tobacconists, subsection 2, again subject to compliance with any requirements which may be prescribed by the Scottish ministers. It also provides a general exception in respect of wholesalers, and again subject to compliance with any requirements which may be prescribed by the Scottish ministers. My Lord said the legal effect of Section 1 is therefore to establish a statutory basis for the regulation by Scottish ministers of the display of tobacco products in places where such products are sold. Its short-term practical consequences will depend, in the first instance, upon how Scottish ministers exercise their regulatory powers. The Court is not equipped to predict the ultimate long-term effects of the provision, nor does it require to do so in order to identify the purpose of Section 1. The extrinsic material indicates that the purpose of Section 1 was to enable Scottish ministers to take steps which might render tobacco products less visible to potential consumers and thereby achieve the reduction in sales and thus in smoking. The legal effect is consistent with that purpose. So I say, my Lord here, specifically in his speech and in his analysis, drew the attention to the requirement of directness as an element of the test. And that's also consistent just with a small part of what my Lord said in paragraph 124.
What I was addressing in 133 was it set out in 132, it was the argument that the purpose of the provisions was the protection of health. I mean, this was effectively restrictions on the display of cigarettes, and that the purpose was the protection of health, which was a reserved matter. And the approach I took to it, as you've just shown, was to say, well, was to look at more immediate purposes rather than an ultimate purpose, which who knows whether or not it would be achieved.
Yes, I understand that from my Lord's reasoning. But what's interesting is certainly the attention to detail and the need to understand whether it was more than an incidental or indirect effect. And that was really something that my Lord also touched on when he was dealing with a slightly different matter in paragraph 124. Because in that paragraph, my Lord was dealing with a situation where a provision is enacted to achieve a number of objectives, and it might relate to more than just one matter that's reserved. I think the language my Lord used here is also important. So I think in 124, my Lord was saying in particular, although section 29.3 refers to the purpose of the provision in the singular, in real life legislation may be enacted in order to achieve a number of objectives. In such a situation, it may be unrealistic to regard a provision as relating only to a single matter, and it's possible that in such a situation, one of the matters to which it relates may be reserved, and another may not. And at that point, my Lord borrowed the hypothetical example given by Lord Roger in Martin against Most, and it was a very obvious example of where simultaneously one might be dealing with a devolved and reserved matter. I don't need to go into that. Goes on to say this, though: unlike the position in Canada, where legislation must be characterised as relating to only one predominant matter in order to avoid a conflict between the two lists, it may be arguable that the Court is not driven by the logic of the Scotland Act to follow that approach. I would therefore wish to reserve my opinion as to the correctness of the argument of counsel for the respondent, that even if the provisions in issue relate in more than a merely incidental or indirect manner to the regulation of the sale of goods to consumers, they are nevertheless within devolved competence because their predominant purpose is the protection of health. Now, we're looking at a slightly different aspect here, but again, my Lord turns to looking at this language of incidental or indirect, and that's exactly how Lord Mance approached the issue in the Welsh asbestos case. He was looking for a directness as an element to the test, and I think that's also consistent with what Lord Brodie said at page EF 623 to 624 at paragraph 202. It's really at the bottom of that paragraph, at the bottom of page 623, when he's dealing with the provision that relates to reserved matters. And at the bottom of 623, he said, a provision may, and indeed probably will, have a variety of effects, some more remote than others. In such a case, it is the more proximate or direct or crucial effect that's of importance. Incidental effects are to be disregarded. As was put in the passage from W&A MacArthur Limited against Queensland, quoted by Lord Walker in his opinion in Martin against Most, we have to determine in each case what is the subject of the legislation, what the subject of the Act with respect to, what it affects, not things or operations it may indirectly affect. So that I say that rather than Lord Mance's approach being an outlier or inconsistent with that expressed by others, it's entirely consistent with what his approach is entirely consistent with the way in which my Lord and Lord Brodie approached the matter in the Imperial Tobacco case in the Inner House. There was no criticism of this approach at all by Lord Hope in the House of Lords, and it's important to have regard to when we think about the way in which we approach the reservations in the Scotland Act and just how we deal with the question of the subject matter, whether or not it concerns subject matter of a devolved or reserved power. So I say that further consideration to this particular issue was given by this court in the Continuity Bill case. That's authority at tab 11, volume 1, and at EF 822. And that was a case in which this court held that a bill of the Scottish Parliament would only relate to the reserved matter of international relations if, by its terms, it sought to disrupt or interfere with the conduct of international relations by the UK government.